Am I entitled to an annulment in New York if my marriage has not been consummated? If your marriage has not been consummated, you may be wondering whether that alone is enough to end it through annulment in New York. In New York, a marriage may still be legally valid even if it has not been consummated. Annulment is available only in limited circumstances involving an incurable physical incapacity under New York Domestic Relations Law Section 140d. An annulment is a legal proceeding that declares a marriage invalid, as if it never legally existed. This is different from a divorce, which ends a marriage that was once valid. New York recognizes void marriages and voidable marriages. A void marriage was never legal in the first place, such as a bigamous or incestuous marriage. A voidable marriage is considered legally valid until a court declares it invalid through an annulment proceeding. To obtain an annulment of a voidable marriage, the filing spouse must prove that one of the specific legal grounds listed in DRL Section 140 applies. Under DRL Section 140d, a non-consummation annulment requires proof that one spouse has an incurable physical incapacity that prevents sexual intercourse. The physical incapacity typically must have existed at the time of the marriage. If the condition developed after the wedding, it generally does not qualify as a basis for annulment. The spouse seeking the annulment must usually show that they were not aware of the condition before the marriage took place. The condition must be permanent and incurable. If the physical incapacity can be corrected through medical treatment, the court is unlikely to grant the annulment. Medical evidence plays a central role in these cases. Consummation refers to the first act of sexual intercourse between spouses after the wedding ceremony. New York law does not require consummation for a marriage to be legally valid. Absence of consummation alone does not justify an annulment. The legal question is whether one spouse was physically incapable of consummating the marriage due to an incurable condition that existed at the time of marriage and was unknown to the other spouse. It is important to understand the distinction between impotence and infertility. Impotence refers to the physical inability to engage in sexual intercourse. Infertility is the inability to conceive or produce children. Under New York law, infertility is not a ground for annulment. If a spouse knowingly concealed infertility before the marriage and having children was essential to the decision to marry, fraud under DRL Section 140e may be an alternative ground. New York law sets a strict deadline for filing a non-consummation annulment. The action must be commenced before 5 years have passed since the date of the marriage. Once 5 years have passed, a non-consummation annulment is no longer available. If the deadline has passed, divorce based on an irretrievable breakdown for at least 6 months may be the appropriate option. Because a non-consummation annulment requires proof of an incurable physical condition, medical documentation from a qualified physician is essential. The court may expect diagnostic results and expert testimony confirming that the condition prevents sexual intercourse and cannot be corrected. The burden of proof rests with the spouse seeking the annulment. If a spouse is physically capable but simply refuses to consummate the marriage, that refusal alone does not qualify under DRL Section 140d. However, depending on the circumstances, a deliberate misrepresentation about the intention to consummate the marriage may support a fraud-based annulment claim. An annulment declares that the marriage was never legally valid in the first place. A divorce acknowledges that a valid marriage existed and then dissolves it. In an annulment, the court may still address property division under equitable distribution principles. Children born during an annulled marriage remain legitimate under New York law. The court can issue orders regarding custody, visitation, child support, and spousal maintenance in an annulment proceeding. Annulment cases require filing a summons and verified complaint in the New York Supreme Court in the county where either spouse resides. At Juan Luciano Divorce Lawyer, this law firm helps individuals throughout New York City understand whether their circumstances meet the legal requirements for annulment. A knowledgeable lawyer can evaluate the medical and factual details of your case and explain your options under state law. An experienced attorney can also help prepare the required pleadings and present the necessary evidence to the court. If you are considering annulment based on non-consummation, speaking with a Manhattan attorney about your situation is an important first step. For guidance on annulment or divorce, contact Juan Luciano Divorce Lawyer, located at 347 Fifth Avenue, STE 1003, New York, New York, 10016, United States, or call 212-537-5859 to schedule a consultation with this law firm.